All right. Good morning, gentlemen.
Good morning.
Good morning.
I apologize. We're encountering some technical difficulties. At any rate, let me. I just want to confirm, Mr. Slayton, you're going to start with Posse, representing Posse, excuse me, for 16 minutes. Is that correct?
Yes, Your Honor.
Okay. And then Mr. Gaston is going to then, representing Pacer, is going to start with his 16 minutes. Is that correct?
Yes, Your Honor.
Okay. And then third is Mr. Clinton for representing Parsley for 10 minutes.
Yes, Your Honor.
And then Mr. Slayton will do rebuttal for Posse for 8 minutes.
Yes, Your Honor.
Okay. I just wanted to be sure we were all on the same track. And at this time, our clerk will call court, please.
Yes. The Court of Appeals for the 8th District of Texas is now in session.
Thank you. And at this time, the court calls the case 08-20-00061-CV, Posse Energy, Parsley Energy versus Parsley Energy, Pacer Energy, and Posse Energy. Gentlemen, in this particular case, as you can well imagine, we have spent quite a bit of time examining and becoming as familiar as we possibly can be on the facts. So you have limited amount of time this morning, if that aids in your presentation. But we have reviewed the record. We have reviewed your briefs. We've discussed the facts and the legal issues extensively with the court staff. So with that, Mr. Slayton, you may proceed.
May it please the court. Matt Staten on behalf of Posse Energy. The trial court here ordered and declared that the 1992 acquisition agreement and assignment conveyed nothing in the Morgan lease below 8,900 feet. This was reversible error, and it rewrote and engrafted depth limitations in these agreements where none previously existed. And let me just briefly cover what I intend to talk about, and then we can address it in more specificity. First, the acquisition agreement and the assignment expressly and broadly conveyed all Morgan lease interests without depth limitation. There's no writing anywhere mentioning 8,900 feet as a depth limitation, deep rights, shallow rights, or another depth limitation, not even the property description exhibit that's relied on by my opponents. And even more important, the record here shows that the parties knew how to limit depths. Elsewhere, they did so as part of this transaction when describing other properties, but chose not to when regarding the Morgan lease. Now, just a brief framework for what the Texas Supreme Court expects of all of us. This court's task, according to Piranha and other recent decisions, is to determine the party's intent as expressed within the four corners of these documents. When these written instruments are sufficient, you need not resort to anything else. You also must harmonize and not render meaningless any provisions. And with that framework, I'd like to talk a little bit about the assignment in this case, because it is the governing document, along with the acquisition agreement, that controls the conveyance of the Morgan lease interests. This assignment broadly conveys all Morgan lease interests. And how do we know that? Because if we look directly at the document, paragraphs A through F, it's a two-step process with the assignment. Paragraph A conveys the Morgan lease interests described in Exhibit A. But these lawyers and these parties wanted to express more. And when they got to paragraph B, they said, without limitation of the foregoing, we want to convey all other rights of any kind. And if you look at paragraph B, subsection C, it's as comprehensive as you can get. It says all rights, options, titles, and interests of the seller related to the subject properties are conveyed. That's the kind of language that expresses the party's intent. It also contains in paragraphs B through F, language like all interests related to or appurtenant to in any way the property described by the Morgan lease exhibit. And in paragraph F, it has another catch-all saying that all of Westland's rights pertaining to any of the aforementioned properties are going to be conveyed. So if we turn back to the acquisition agreement briefly, I know the court has read the briefs and the documents, and I won't get into the severe depths of the acquisition agreement, but basically it says the buyer acquired all of the seller's interests. Interest is a defined term. Interests under the acquisition agreement says it shall mean the properties described by the Morgan lease exhibit, but it shall also mean all right, title, and interest of the sellers in the properties set forth by those property description exhibits. And this necessarily includes all depths. This is the kind of language that, again, can't be ignored when we're harmonizing both the property description exhibits that the opponent has relied on heavily and this assignment and the acquisition agreement. Here, it's clear that Westland conveyed all categories of interests related to the Morgan lease. So let's talk about what I call Exhibit A to the assignment, which is the Morgan lease property description. It contains no express depth limitation. It does not make any reference to a depth of 8,500 feet, even though that's what the trial court found that it said. Exhibit A also identifies the Morgan lease by date, recording info, working interest, and non-participating royalty percentages. But none of those things are a conveyance, and none of those expressly limit the depths. In some...
Counsel, if I can just to clear up something for me, if it does refer to the proration units, I mean, that's both a description of the horizontal area that the well covers, but doesn't a proration unit also cover a specific depth, particularly if you're talking about a field? In other words, you could have a field at a certain depth and then another field with its own field rules at a lower depth.
That is not my understanding of the proration unit. My understanding of the proration unit is that it defines an acreage and the maximum amounts allowable that a well can produce on that acreage. And these proration units were not either depth limited anywhere in the Morgan lease, and they weren't depth limited anywhere in Exhibit A. And so merely referring to proration units as part of a property description wouldn't limit the depths here. How are parties to know by merely referring to a proration unit that everyone has agreed that the depths have been limited to everything above 8,500 feet? You can't tell that from the language of the document, because what we have is broad conveyance language in the assignment, broad conveyance language in the acquisition agreement, and then a property description exhibit that references proration units and other information that merely just describes the Morgan lease properties that are at issue here.
Well, and then if I may, the thing that I'm having difficulty with is in part of the description, there's a reference to a mineral interest, I believe it's 24.2%, which is reflective based on the original leases of the shallow rights, whereas the 72.7% interest is reflective of the deep drilling rights. So doesn't the assignment and the acquisition agreement reflect that 24.2% interest, which is, in my mind, code for the shallow rights?
Your Honor, that's a great question. And that's probably one of the things that the trial court was hanging his hat on when he decided this case. But the exhibit's recital of a 24% working interest, which is what that is, it doesn't mention that it's a working interest in the shallow rights, and those are the only things being conveyed here. It certainly reflects that interest that exists as part of a property description. Remember, Exhibit A is describing the property. It's not conveying anything. The assignment is the conveying document. And
Right.
unless and until it has carved out specific rights, like deep rights or shallow rights expressly, then it can't be read that way. There's no doubt that it gives a lot of information about the Morgan lease. Again, it says that it covers the quarter sections listed. It has warranty language, the insofar as language. It mentions prorated units. And it also mentions these interests that are working interests that at that time were in the shallow rights. But that doesn't mean that the 72% interest in all rights below 8,500 feet that Westland owned, that it wasn't trying to and didn't express its intent to convey those to Posse's predecessor. It's just not granting language.
you don't, so I guess what you're arguing is that even though the 72.7% interest is not delineated, that the any and all language then included that. So that
Correct.
trumps the specific 24.2% interest.
Well, again, that's our argument, and our position is that this is a property description exhibit, and that 24% working interest that's listed there is just listed per well, per quarter section as a property identifier. In no way does it shape or limit the broad conveyance. So yes, I'm agreeing with the presumption of your question, but let me point out something that's equally important. The deep rights that were conveyed to us, which were in the form of 72.7%, that's our position. We say that those deep rights were conveyed by all of the arguments that I've just made. Parsley, who has a conditional cross appeal, also agrees with us that deep rights were conveyed. They just say that they were in the amount of 24% that's listed here. Pacer says nothing. You were not conveyed any deep rights. So I want to make sure that the court understands.
No, I understand that. And yes, no, we understand that part of the argument.
Okay. Thank you, Your Honor.
You're welcome.
I guess to further answer your question, the 24% working interest that's listed per well can't somehow magically alter the conveyance language that already exists and was expressed by the parties. And that's our position as to that number and why it's there. I'd like to touch, if I can, while I have time, about the consistent reliance that Pacer has made on extraneous evidence from the 1980s and these alleged surrounding circumstances. The court understands that it cannot construe separate transactions together. And in the 1980s, different parties were a part of some different transactions that involved deeds of trust, and those deeds of trust were securing collateral in the shallow rights. But in 1992, I want to make clear that Westland and Posse's predecessor engaged in an asset purchase agreement. This was a pure different transaction, and you can't go back to those 1980s bank loans and somehow extrapolate parties' intent when you had different parties and a different transaction altogether. And one more thing I would mention is, apart from being separate transactions, these are certainly not surrounding circumstances that would inform the party's intent. This court knows what surrounding circumstances are, and when different parties are engaged in a different transaction involving a different purpose in the 1980s, in a different decade, we know that those aren't the type of things that can inform the intent of the parties that are different in 1992. And the key under URI and other Supreme Court authority is that it's been the appellee Pacer's attempt to use those surrounding circumstances to alter the language of what's already here. They want it limited to the shallow rights, and as I've already covered, there's nothing anywhere expressly limiting this transaction to the shallow rights.
So my question is if the assignment references the Morgan leases, I believe it's A, B, C, D, and 1, and then, incorporates to me by reference, and then when you review those leases and those leases are specific as to the depths, isn't that something we can consider?
Well, you can obviously consider those things. It's my understanding, and I would have to double check this, that the lease, especially as to prorated units, isn't depth limited. So the Morgan lease doesn't contain that kind of a limitation.
I'm saying the Morgan leases A, B, C, D, and number 1 do have depth limitations.
Right. Those wells that were then existing were in the shallow rights. There's no doubt about that, Your Honor.
Right. So what I'm saying is if the assignment references Morgan leases A, B, C, D, and number 1, then are we not able to look at those leases?
You're able to look at all of that information, of course, but back to the original argument of what is the acquisition agreement and what does the assignment expressly say? It says that they're conveying every right interest possible that's in any way related to the Morgan lease. And so when you use that kind of broad sweeping language over and over and over, you're saying, here's our reference point, which is the Morgan lease properties that are at issue. And the Morgan lease properties at issue are identified in the property description exhibit. And there's no doubt there were wells being drilled in the shallow rights, but the exhibit, nor the acquisition agreement, nor the assignment say anything about limiting the depths of what's being conveyed. And so without that express limitation, there's no way that the parties could have intended the result that the trial court reached.
Okay, so then my next question is, the Morgan leases that we're speaking of, A, B, C, D, and number 1, is there another document that you're calling Morgan lease as opposed to the Morgan lease A, B, C, D, and number 1?
There is a Morgan lease in the record, Your Honor.
Just the Morgan lease for the entire.
For the entirety, I believe it's 2,200 acres, but this property exhibit A, is referring to the disputed tracts, which I believe is roughly about 800 acres. So there's a broader Morgan lease that covers more properties. And this is related to, as you've identified, these quarter sections that have wells Morgan A, B, C, D.
And number 1.
And number 1.
All right.
Have I answered your question? I'm trying.
You know what? I didn't see, and obviously I'll review. I did not see an overarching Morgan lease.
Right. I don't want to speak for my opponents, but I don't think any of us have alleged that changes the analysis. I think all three of us agree that it's the acquisition agreement, the assignment, and this exhibit. But I would say that the lease covering more acreage sort of informs this language, this insofar as and only insofar as, because that's the warranty language here. When we're talking about the Morgan lease, these parties wanted to make sure that we were talking about the disputed tracts, which is the roughly some 800 acres, which is in dispute right now, and not the overall, all the lands covered by this Morgan lease.
Okay, thank you.
I would, in my limited time left, I'd like to touch on
Westland, and that was limited just to the 22%, or I guess it was half of the 22%. So is that a circumstance that we could consider?
Well, you certainly can't consider a circumstance that occurred after the fact, and the reconveyance deeds were in 1998. So initially, if you're going to construe what happened and what's the party's intent in 1992, you wouldn't construe that as a surrounding circumstance. But with that said, we also disagree that the conveyance deeds could somehow alter the 1992 conveyance, and we disagree that with the proposition that the reconveyance deeds did anything more than merely reassign 1/2 of the Morgan lease interests that were conveyed in 1992. So we just have we don't believe that it goes as far as Pacer and Parsley have argued the reconveyance deeds go.
Thank you.
Thank you.
Mr. Gaston?
Thank you. May it please the court. Jeremy Gaston for Appali Pacer Energy Limited. At issue is the scope of this 1992 assignment. The objective intent of the parties for that assignment we actually have in black and white in the acquisition agreement, which states an intent to transfer properties that fall into one of two categories. Category 1 are properties that were collateral for bank debts that Westland had. Category 2 are called, quote, additional properties, capital A, capital P, additional properties listed on Exhibit F to the acquisition agreement. The question, or one question, is whether either of those categories contained any deep rights in the Morgan lease. And for that, the answer can't be disputed. Exhibit F, the additional properties, aren't even in Upton County, so can't contain deep rights in the Morgan lease in Upton County. And the properties that were collateral for bank debts also don't include any deep rights in the Morgan lease. And we know that because the security documents referenced in the acquisition agreement and the note purchase agreement, the security documents, which do date back many years, have a deed of trust that has a depth limited Morgan lease as collateral, 7194 to 8900 feet, and the amended deed of trust, which carries forward that collateral but doesn't add anything more. In the trial court, Posse's argument was Westland had mortgaged all of the rights in the Morgan lease for those bank loans. And if that had been correct, I think it would be difficult to reconcile the intent of the acquisition agreement with the assignment, but that wasn't correct, and Posse's not reiterating that argument. I think it's important to note that these references to these security documents, and even though that was a different transaction, still falls within the Supreme Court's rule that when documents are either made subject to or reference other documents, you have to look at those other documents for all documents that are in your chain of title. And those are the Burlington and Gulf Oil cases that we cite at pages 23 and 46 of our brief. So yes, if you were dealing with a single transaction, you might have documents that don't reference each other, but because of the same transaction, you look at them. Here, we don't need that. These documents expressly reference each other. The assignment is subject to the acquisition agreement. The acquisition agreement references the security documents and no purchase agreement. The reassignment is subject to the acquisition agreement. Now, how did the parties implement the intent of the acquisition agreement? They did so through an assignment, and the assignment has two components. It has a paragraph A with an associated exhibit A, and then it has 5 additional paragraphs B through F. And I think you have to look at those as 2 separate analyses. First, what does paragraph A do? It conveys property described on exhibit A. So you have to look at exhibit A. What does exhibit A describe? Well, you're expecting, knowing the party's intent, that it's going to describe some kind of depth limited shallow leasehold. And that expectation is met as soon as you get to exhibit A at the very top. You've got a line at the top that says Sprayberry Trend, Upton County, which is a shallow field. And you've got Morgan 1, A, B, C, and D, which are designations of wells that Parker and Parsley drilled in 1979. They were drilled pursuant to depth limited leases, 7194 to 8900 feet. They existed at those intervals. And when you go from the top of the page to the property description, it becomes even clearer, because the exhibit is describing not the Morgan lease, period, but the Morgan lease insofar and only insofar, and that's 4 words in all capitals, insofar and only insofar as that lease covers the proration unit for 5 listed wells, Morgan A and 1, 2, 3, 4. Now, we've cited a couple cases where the phrase insofar and only insofar is shown to be a limitation. It can limit a description. Here it's limiting the property description. And even as just a matter of common English usage, it's clear. And I have an example that I'll use here and another part of the argument. If I have a condominium that's 10 stories tall, and I own the condo on the 10th floor and I own the condo on the 1st floor, and I'm conveying to you all of my interest in the building, insofar and only insofar as it covers the 10th floor, the property described and conveyed is the 10th floor, not the 1st floor condominium, the 10th floor condominium. Here, the conveyance is, and the description of property is not the Morgan lease, period. It's the Morgan lease insofar and insofar as it covers the 5 proration units for the 5 wells. So then we have to go to, what does that mean? What is the proration units for the 5 wells? And at page 43 of our brief, we've tried to illustrate this graphically. And I know in opposing counsel's argument, I think he's taking issue with our concept of proration units, but Posse's reply does not take any issue with our illustration there. And what that illustration shows is the side view of property, and you've got one oil reservoir, a field at one level, and then you have another oil reservoir or field at a deeper level. Each of them has a well completed within them. Each of those wells was drilled from the same surface acreage, and each of them under the Railroad Commission rules can be assigned that same 160-acre surface area for proration purposes. But they're distinct proration units. They're stacked on top of each other. And the reason you can stack them on top of each other is because proration units are about allocating production from fields. And so apart from certain circumstances, such as those involving horizontal drilling, you can have proration units at different depths in different fields, but you couldn't have the same acreage associated with 2 wells that were in the same field. And a more fundamental point, and we also show this in the diagram, is that the two proration units are actually narrower than the fields that they're in. Now, they could have been as big as the fields that they were in if the leasehold under which they were drilled had expanded, had covered the entirety of the field. But here, the proration unit can't extend beyond the top and bottom of the leasehold on which they were drilled. And here, Parker and Parsley created these wells in 1979 pursuant to a depth-limited lease. And at that point, after they've said to the commission, these wells can be drained from this field within this 160-acre aerial acreage, they couldn't go around and tell people, well, look, we've also got a proration unit that goes way up into the shallower depths and way down into the deeper depths, because they didn't own that. The well was not at those depths. The proration unit, the production from the wells was not at those depths. If you understand that conceptually, then the meaning of Exhibit A's limitation on the Morgan lease becomes very clear. We've got a conveyance of leaseholds that are inherently depth limited, and it's a matter of title. You trace it back, you look up the lease that Parker and Parsley drilled the wells under. You can look in the security documents. You see the depth limitation from the get-go. You can look in the production reports for these wells with the Railroad Commission showing the producing intervals. And so the fact that there's a limitation in the grant means you don't need to specify a separate depth limitation. Now, you could, but you didn't need to, because the conveyance is limited from the get-go. And again, confirmatory language referencing the Sprayberry trend, confirmatory language in the interest assigned in all capitals, interest assigned, underline the 24 point such and such percentage, which exactly matched the shallow interests that Westland had, and obviously are not at all the 72.7% interest in deeper rights. Now, this is also consistent with the acquisition agreement's statement of conveying property that was bank collateral. Now, there's another half of the argument, which is, what about paragraphs B through F of the assignment? Did they go beyond the leasehold described by the property in paragraph A? Here, I would say Posse's argument is what you would call a kind of hand-waving argument, where you state your premise, which is we have all these extra paragraphs and they are long and they have broad language. And then you state your conclusion that they must somehow have conveyed the deep rights, but you just kind of wave your hands and hope the audience will go from the premise to the conclusion. But that's not the way to do an analysis. You have to look at paragraph B, C, D, E, and F. And it's tedious because they're long and repetitive and small and single space. And on page 54 of our brief, we've tried to rewrite them in a simpler fashion. And so far, no party has contested the way we've tried to summarize that. And I would just encourage the court to look at that, look at the original language, and just obviously decide for itself, do any of these extra contract property rights, do they go beyond the leasehold described in paragraph A? Because if the court agrees that the paragraph A leasehold as described is a limited leasehold, then the fact that you add rights referring back to that are only going to give you rights related to that shallow leasehold. And so in the context of my condominium example, I may assign all of my interest in the building insofar as it covers the 10th floor. I may also assign parking spaces. I might assign the personal furniture and appliances in that floor, the contract rights with the condo association, that property's interest in the shared common area. There are numerous rights that can be assigned in connection with a leasehold that don't cover some separate leasehold. And our position is that that's what those paragraphs are doing. Many of those rights would probably transfer as a matter of law because they run with the land. Others might or might not, but attorneys being attorneys are going to try and spell out as many as they can. And I think the important point, one of the important points of the reassignments in 1998 is that they're simpler and they use shorter language. Easily see that they are simplified ways of doing what the assignment did. So in 1998, Posse reconveyed and represented that it was reconveying exactly half of what it had obtained under the assignment. And it did so with language that's written similarly. It's in two parts. It has a part about the leasehold and it has a part about these pertinent property rights, such as the well equipment and other interests. The specific language is an undivided 12.11665% working interest and 10.60206 net revenue interest into the Morgan 1 and the Morgan A leases. And I think that phrasing is consistent with our position. You could say the Morgan A lease, and everyone knows this is the Morgan A well and it's depth limited under a lease that Parker and Parsley had. Or you could say the Morgan lease insofar and only insofar as it covers the proration unit for the Morgan A well or the Morgan 1 well. And then the reassignments convey the personal property, fixtures, improvements, wells, equipment, etc. And that's comparable to the paragraphs B through F that are trying to spell out additional rights that you expect are going to be reconveyed back. And at a minimum, there's just no way to read the reassignments as purporting to reconvey half of a 72.7% interest in any deep rights. Deep rights aren't mentioned. That such, half of that would be 36.35%. That's not mentioned. The reassignments, the assignment, and the acquisition agreement together can only be read consistently in one way, which is that Westland conveyed depth limited rights in the Morgan lease in the Sprayberry Trend area, as defined by 5 depth limited wells and their proration units. And in 1998, Posse reconveyed half of those depth limited interest right back. And if the court agrees with that analysis, then we would say the court should affirm the trial court's judgment. And unless the court has specific additional questions, that's what I was presenting. And
Just quickly, counsel, if you could kind of address in the acquisition agreement the definition of the term interests. And I guess that's paragraph 2A. I mean, it has some language. 2A starts, all rights, title, and interest of sellers in the properties set forth in exhibits D, E, and F. So, I mean, I guess they're reading that to say, okay, D, E, and F define what the properties are, and then the first part of that sentence would say, basically all of your rights in those properties. And then I think the next sentence kind of maybe says the same thing. So tell me how you view that, please.
And Your Honor, just so I'm clear, are you looking at page 3 of the acquisition agreement?
Yes, 3, and it spills over to 4.
Yes. So at page 3, midway down paragraph 2, it says, as used herein, the term interest shall include all properties pledged to secure payment of the note A and note B pursuant to the security documents for the payment of the notes as set forth on and with the exceptions noted on exhibit I hereto, plus additional properties owned by the sellers as set forth on exhibits D and E hereto, also pledged as collateral for the notes. So D, E, and I are all stated to be collateral for the notes. And the only collateral for the notes with respect to the Morgan lease are the shallow rights. And that's in the original deed of trust for the notes. This deals with note A, although there were multiple notes. And our point would be that exhibit D here is the same as exhibit A to the assignment. And the property, our position is that the property described on exhibit D and the property described on exhibit A to the assignment is the Morgan lease insofar and only insofar as it covers the proration units for the 5 listed wells. And that is a depth limited description. And so the properties owned by the sellers as set forth on exhibit D here in the acquisition agreement is the depth limited property. It's the collateral, so it matches that. And it matches the limitations within exhibit D and exhibit A, which are exhibit A to the assignment, which is a duplicate of exhibit D to the acquisition agreement. And then of course, exhibit F are the additional properties which are outside Upton County entirely. I think I was answering the question. Obviously, if there's any follow-up, I'm happy to address.
No, thank you.
All right, thank you. And now, Mr. Clinton, you may proceed.
May it please the court. I want to start by acknowledging the unusual circumstance that our client is in that there were 3 constructions of the deed instruments in the trial court. There was a plaintiff's construction, which is that they had acquired all of the deed rights. There was Pacer's construction, which is that they had acquired none, or their predecessor in interest had acquired none. And then there was ours that took a middle ground. We won everything. Pacer's construction gave us everything that we asked for. So even though it's a slightly different construction, we still prevailed in getting the entirety of the interest that we asked for, and therefore we didn't have any duty to file a notice of appeal because you don't appeal a judgment that you have no complaint about. But we did so in the abundance of caution merely to make sure that we could advance our argument in the alternative, which was to the extent that the court did not believe that it shouldn't affirm summary judgment on the grounds that Pacer argued, that our alternative ground would go forward. And the plaintiffs have beat us over the head a little bit about changing our position. We're not, I don't think we have any duty to contest a judgment, especially one that's in our favor. I've never seen any case that said we had a duty to contest a judgment in our favor. So we aren't contesting the grant of the motion for summary judgment by Pacer. We are simply advocating an alternative position only to the extent that the court doesn't believe in Pacer's position, which I happen to believe is the most accurate reading of the circumstances. I believe that Pacer's position is correct and that it is an accurate reading of the instruments. But again, just out of abundance of caution, we wanted to preserve our ability to make the alternative argument. And the alternative argument is pretty simple. It is that there is no reasonable construction of the instruments as having conveyed from Westland to plaintiff's predecessor in interest a 72.7% working interest in the lease at any depth. When you read that the words that the parties used in these documents, you can't get to a 7.7% depth. And I would really start by the heart and soul of the case, which is the assignment and bill of sale. It's Exhibit D to Pacer's brief, if the court has it in front of it. I think walking through it is most illustrative of the issues before the court. It says Westland conveys to Peter Paul, which was the general partner of Posse's, the plaintiff's here's predecessor in interest. Grant, bargain, sell, convey, and transfer and assign the following, all of which are called subject properties. A is the meat of it, the oil and gas leases, oil, gas, and mineral leases, and other estates and properties which are specifically described. They use the words which are specifically described in Exhibit A attached here too. And you go to Exhibit A, which is a couple of pages later, 898 in the record, and it is the Morgan lease interest. And Exhibit A has 2 pages to it. You'll notice on the next page it's the Pembroke unit leases. What's interesting here is that the Pembroke unit, they assigned the entirety of the lease. They listed the entirety in the lease. They didn't specify any subportion of it. But with respect to the Morgan lease, which is at issue, the parties chose 2 things to highlight with all caps, and that we have to believe that they meant something by them. So we start at the top. The Morgan 1A, B, C, and D are the wells at issue. Sprayberry Trend is the formation, and so to answer Justice Alley's question, yes. A proration unit is a 3D unit. It has 3 dimensions. One of the dimensions is the formation that it's drilled in, which here is identified as the Sprayberry Trend. The oil and gas lease dated 1974 from the Morgans to DE Billings, and then the parties used all caps to specify their emphasis, insofar and only insofar as the lease covers the proration units for the following wells. The wells are again listed on the left side. The geographic areas is the size of the proration units here. The A numbers are merely abstract numbers, but look under the words capitalized and underscored, interest assigned. Why would the parties capitalize and underscore? Because they wanted to make clear what the interest assigned was. And they used the words 24.2333% WI, which is working interest, or the leasehold interest at issue. So the parties did the work for the court in telling them what interest they intended to assign. And this is where this lease differs a little, these documents differ a little bit than the one in Piranha. The court said in Piranha that we looked to the exhibit to find out what exactly was assigned, but that the court couldn't tell. A lot of stuff was listed in the exhibit, and the court couldn't tell. In fact, the court said that had it only been the exhibit, it would have been ambiguous, because they couldn't tell from the exhibit what precise interest was assigned. Here, the parties have done the work for the court by underscoring and capitalizing the interest assigned, which is a 24.2333% working interest. We cannot ignore the words of the parties. Courts, at the very worst, are required to give meaning to all of the words of the instruments. And the words here underscored and in all caps, the interest assigned is 24.2333%. Now, plaintiff has three arguments, as I count them, for ignoring all of the language that goes after the word lessee. You know, all of insofar and everything after that, plaintiff says we should ignore, and they make three arguments. The first is the one that your honors have already referred to, which is this, it's all of everything. Anytime you use the words all right, title, and interest, it's all of everything. Both the Texas Supreme Court and the Fifth Circuit have explicitly rejected the argument that all right, title, and interest to something means it's all of everything. What they say is it's all of what follows. It's not all of everything. It's all of what follows those words. In Piranha Partners versus Newhoff, the court called out the argument. It says, Piranha repeatedly asserts that the assignments granting clause conveys all of Newhoff Oil's right, title, and interest in and to its overriding royalty interest. But that's not what the clause says. I'm reading verbatim. Instead, it says that Newhoff Oil conveys all of its right, title, and interest, and the court used italics here, in and to the properties described in Exhibit A. So it wasn't that the court was giving more meaning to all right and title and interest. It was saying we can't tell from Exhibit A, so that's why we have to go back and try to figure out which of the properties listed in Exhibit A were transferred. The Fifth Circuit rejected the exact same argument in SunWest Operating versus Classic Oil. There, the court says the weakness of this argument is that although the terms properties includes the leases and lands, the term leases and lands are defined by reference to Exhibit A. As stated above, Exhibit A limits the interest conveyed to the Tompkins leases to the acreage allocated to the unit. Accordingly, the assignment of all of Askenor's right, title, and interest to the properties simply means that Snyder conveyed all of its interest in the Tompkins leases as limited by the description in Exhibit A to that within the Velma Daniels gas unit. You do not read all right and title and interest to expand the quantum of the interest conveyed, but rather to say that it gets all of the accompanying rights that go along with it. Second argument that plaintiffs make, and you heard it here, was that insofar and only insofar as mere warranty language. There is nothing to suggest that that's true. The warranty language is elsewhere in the assignment agreement. And the case that plaintiffs cite for that position does not so say. The plaintiffs cite Walker versus Foss for the proposition that insofar and only insofar is warranty language. Those words are not in the case Walker versus Foss. It does not construe insofar and only insofar. It construes subject to. And even then, it says, quote, the subject to clause limits the estate granted. And both Key Production Company versus Quality Operating out of Waco and PetroPro Limited versus Upland Resources out of Amarillo both hold that the phrase insofar, and this is quoting from PetroPro, the phrase insofar and only insofar constitutes a limitation on the grant. It limits the extent of the interest granted. And that court goes on to distinguish between rights and interess. It says that when you use the words insofar and only insofar, you are limiting the character of the interest granted. But of course, you're not limiting all the accompanying rights that go with it. You're just specifying the quantum of the interest conveyed. And the last argument they make is that paragraphs in their brief, they say A, B, and C expand the quantum of the interest conveyed of the assignment agreement. C in their brief is a typo. They're actually quoting from paragraph D. So A is the one I've already read, which links specifically to the interest specifically described in Exhibit A. Paragraph B, if you go 1, 2, 3, 4, 5, 6 lines down, you'll see that all of those things are modified by the word specifically described or referred to in Exhibit A. The language that plaintiff read to you in B was a misquote, because that language says interest of assignor related to the subject properties which grant assignor the right to obtain or otherwise earn additional rights. So those are option rights. You can't stop reading in the middle of a sentence. You have to read the entirety of the sentence. And the same goes for D. If you go 1, 2, 3, 4, 5, 6, 7, 8, 9 lines down, you'll see which are appurtenant. It lists all the things and it says which are appurtenant to any of the interests specifically described. So you gather all of the appurtenant interests and the appurtenant rights to the interests that are expressly, as the documents say, specifically described in Exhibit A. And Exhibit A specifically describes the lease only to the extent it is insofar and only insofar as it pertains to the lease covering the proration units of the following wells in the interest assigned, underscored, and capitalized. Thank you, Your Honors. I apologize for running over.
I apologize. Thank you. I appreciate that. And so rebuttal, Mr. Slayton.
Thank you, Your Honors. I think one of the things we can take away from Parsley's argument is that they agree with us that deep rights were conveyed. Despite everything that he said, one of the first things he stood up and said is that in the trial court, both Parsley and Posse agreed that deep rights were conveyed. So let's start with that proposition, which eliminates a lot of what he said that followed. Let's also go back to Justice Alley's question, which incorporated the definition of interest, because I think that's crucial here. As the justice pointed out, the acquisition agreement says the buyer acquired all of the seller's interests. And this, of course, is at page 3 of the acquisition agreement. And then it defines interests, and it says interests shall also mean all right, title, and interest of the sellers in the properties set forth in Exhibit D. And again, that property description exhibit contains no express depth limitation. And remember, this is something that perhaps hasn't been touched on enough. The parties knew how to limit depths. If you go back to Pacer's argument and you look at the 1988 deed of trust on page 377 of the record, it is the description of the property. And these parties, the prior parties, even under Pacer's argument, limited the depths to above 7,194 feet, between 7,194 and 8,900 feet. So that was in 1988 that Westland knew how to limit depths. But what about these parties in 1992? They knew how to limit depths too. If you look at page 814 of the record, it is a different property description. It contains virtually the same language as the Morgan lease property description with one glaring exception. The parties said that it only involved the surface of the earth down to the base of the formation. They limited the depths as to that piece of property being conveyed in this transaction. There's reference to proration units. There's reference to this insofar as language. It is almost identical. And what does this show you? It shows you that the parties to this transaction in 1992, when it involved the Morgan lease properties, chose not to limit the depths because they knew how to expressly do it. They had done it elsewhere, and yet they chose not to here. And you cannot ignore that fact, especially when you put it alongside the assignment language and the definition of interest that we've already talked about. Now, I want to talk as briefly as I can in rebuttal about the proration unit issue. The Morgan lease, and we cited this in our reply brief, is not depth limited. So that's a huge factor that undercuts any argument that merely saying there's a proration unit somehow limits the depths, because it's simply not in Exhibit A and it's simply not in the Morgan lease. I want to also talk about the 4 cases that they've continued to reference. Each of those had express limiting language in the actual grant. And here the granting language was the assignment, and there is no limiting language. And there's no similar limiting language in Exhibit A. And we've briefed those cases for you in our reply. Some of them are unpublished and say they can't even be used as precedent. I think you look at Piranha, which had insofar as language. Piranha has taken you down the analysis of what you have to do. And when you harmonize this assignment and this acquisition agreement alongside this Exhibit A, which has no express depth limitation whatsoever, the only conclusion that you can draw is that these parties expressed their intent. Remember, that's the question in this case. What did the parties express their intent to be? And they expressed it in the acquisition agreement and the assignment, and they used Exhibit A as a property description. And if you harmonize all those provisions together, there's only one conclusion. It's that everything at all depths related to the Morgan lease on these disputed tracts was conveyed here. If your honors have any questions, I'd be happy to answer them, or I can yield the rest of my rebuttal time.
Apologize. Judges, do you have any further questions?
No, thank you.
All right. Thank you very much, gentlemen. Your case will be submitted today based on your excellent arguments, the briefs, and the record. And we appreciate your participation today.
Thank you.
Thank you, Your Honors.